my dear colleague, our ranking member, outstanding leader on so many of these issues, chair of Judiciary, ranking member, hopefully chair soon enough. You're underestimating us, you press people. Ranking member of Judiciary Committee, Mr. Richard J. Durbin, also longtime Judiciary Committee member.
Ranking member of Judiciary.
You are.
Yes, you introduced him.
No, I said no. I said longtime member of Judiciary Committee.
Always he fast. Fast Eddie.
Fast Chuck from Brooklyn, New York. Kristine Lucius, the Leadership Conference on Civil Rights, Daniel Goldberg, Alliance for Justice, and Elliot Mincberg, People for the American Way. So thank you all for joining us. Now, we've invited these legal experts to speak today because what we're here to discuss isn't political. It's about the constitutional duty of the United States Senate to advise and consent on one of the most important issues that ever comes before us, the nomination of a Supreme Court justice. And in order to fulfill that duty, the Senate must have the records spanning Judge Kavanaugh's career as a public servant, including his time as staff secretary for the Bush administration. Just this morning, Senator Feinstein released a letter to the National Archives signed by all members of the Senate Judiciary Committee, including longtime member Dick Durbin.
Well done.
Thank you. Requesting the full set of documents. Senator Feinstein's leadership on this issue has been extraordinary. Now, before we continue, I want to make clear for just a sec how aggressive the obstruction is. As you know, breaking all historical precedent, Chairman Grassley has made a partisan request to the National Archives, requesting only a small portion of Judge Kavanaugh's time in the White House, from his time in the White House counsel's office, but not from his time as staff secretary. I note that staff secretary was the most senior position Brett Kavanaugh held in the White House, and he held that job for 3 of the 5 years that he worked for President Bush. So deliberately ignoring the nominee's record during that period would be bad enough, but in this case, it's only the tip of the iceberg. Before the senator sent his request at 5 p.m. on Friday, the Bush Library had already turned over all the White House counsel's office documents to a team of lawyers led by one Mr. Bill Burke. Mr. Burke represents George W. Bush, President Bush, a strong supporter of Judge Kavanaugh. He also represents Steve Bannon, Reince Priebus, and Donald McGahn in the Russia probe. This group has reviewed and pre-screened all the documents. So we're having a Republican lawyer who works for so many Republicans on so many different issues pre-screen these documents. At this point, we have no assurance of being told which documents we're going to be allowed to see and which documents the American people are going to be allowed to see, which documents are withheld, and why they were withheld. This wouldn't be so bad if we also got a full set of documents from the archives. So it appears the vast majority of documents Congress will actually be permitted to see are the documents turned over to us by a lawyer with close ties to both President Bush and President Trump, as well as Mr. Bannon. Let me just sum this up once again. Because of intentional delays and obstruction, the vast majority of documents that Congress will get to review will have been screened by the personal lawyer of George Bush, Steve Bannon, Reince Priebus, and more. Hardly an impartial screener. What are they hiding? Why is there such an effort not to have the documents come forward when that has been the bipartisan precedent of this body for previous nominees? All of a sudden, they've changed the rules. These papers don't belong to Brett Kavanaugh, Donald Trump, George Bush. They belong to the American people. That's why we have an archives. That's why we have an archivist. You can't just turn off and turn on what you want people to see. That doesn't happen in democracy. But that's what our Republicans are doing. Nothing like this has ever happened in the history of Supreme Court nominations. It begs the question, what are they trying to hide? What is in those documents that if they came forward, senators might not want Brett Kavanaugh to be on the Supreme Court? On the issue of documents, the Republicans are putting the secret in secretary. We cannot let that stand in a nation that stands for openness, transparency, and full and free debate, particularly to one of the most important positions in the United States government. Senator Feinstein.
Thanks very much, Senator Schumer. Let me begin with this. This is nothing that is different. This is usual procedure. The letter that Senator Schumer referenced, I even asked to see, even asked the staff questions, are you sure this is the same as was sent out by Republicans on the Kagan nomination? And I have been assured it's identical. We believe that it is our job to review all pertinent information as part of the Kavanaugh nomination process. And this should include documents during his 3 years as staff secretary. Now, staff secretary is a top White House advisor. It doesn't just root memos. It rewrites memos. It puts its own view into memos. The staff secretary often participates, is present, makes statements, and so there is real value in this information. Some Republicans say we want everything but the kitchen sink. That isn't true. We want the same formula that was used for Justice Kagan, and we want to be able to look and see what his knowledge is on key issues and also what he thinks. These are issues like the CIA torture program. I was chairman of the Intelligence Committee for the 6 years that underwent what is a 7,000-page report on torture. Senator Durbin, Senator Leahy have asked questions. They deserve an answer. It is relevant. It's also, if Republicans don't want to review these documents, they don't have to. But it's wrong to stand in the way of senators who do want to review the full record. I've served on 10 nominations. 8 of those nominees made it to the court. And this is the biggest thing that the Judiciary Committee actually does during its tenure. It's the examination of a president's nominee to the highest court of the land, the defender of the Constitution of the United States. I think we're entitled to know what that person believes, what he's written, what he said, particularly in any formal capacity. Thank you very much. Sorry.
Thanks for the opportunity to be here. I've, unlike Diane, I've only been for 7 nominees to the Supreme Court, 1 who withdrew, but I noticed something. During the course of our efforts to review these nominees for the Supreme Court, we were really dedicated to disclosure and transparency, to the point where Senator Jeff Sessions, then ranking Republican on the committee when Elena Kagan was before us, asked for detailed documentation of her service in the White House. I may be mistaken in number, but I think I'm close to 170,000 pages of documents were produced from her time of service in the White House at the request of Senator Sessions and with the cooperation of Senator Leahy. It was done on a bipartisan basis. Let me add, too, there wasn't a single assertion of executive privilege on any single document. It was all there for everyone to review, as it should have been. And then when Sonia Sotomayor was before us, she had a judicial record, much like Judge Kavanaugh, but they wanted more. Again, it was Senator Sessions who said, I want to go back in history to the time before she was on the court when she worked for the Puerto Rican Legal Defense Fund. I want documentation from that experience. And it was produced with a bipartisan request for the information. Again, we were dedicated to disclosure and transparency. That was the starting point. The American people expect us more than anything else to give careful review to these Supreme Court nominees. They know what's at stake here. This is a lifelong decision. It is likely this Supreme Court vacancy will be filled for the life of many living Americans and for generations otherwise. So we know what's at stake here. It is a big deal, not just in tenure, but in fact that when it comes to the issues, there are critical issues, as outlined here, in many other places, that this court will decide, and this justice could be the swing vote. Let me be specific about this, because I've written personal correspondence to Senator Grassley and spoken to him personally about this. It was 12 years ago when Judge Kavanaugh appeared before this Judiciary Committee seeking the D.C. Court of Appeals. At the time, I was concerned about his role in the White House as staff secretary when it came to the question of Mr. Haynes and whether he was going to be a federal court judge. And I asked specifically to Mr. Kavanaugh whether or not he was involved in that. Well, he went further than answering that question, yes or no. He said, I was not involved and am not involved in the questions about the rules governing detention of combatants. Now, that was a statement and reply under oath. He then went on after that statement to be approved by the Senate and to take his seat on the D.C. Court of Appeals. And then, within a matter of months, we found out there was more to the story. We found out he was, in fact, personally present in a heated exchange at the White House over the representation of these combatants by legal counsel, and that he volunteered information about what he thought Justice Kennedy would do if confronted with that question. So the statement he made to us under oath was contradicted by the record that came out later, published, and the record that was verified by the National Public Radio. So obviously raised a question in my mind, well, what's going on here? The question I got from Judge Kavanaugh under oath, it turns out was contradicted by later evidence. And so I wrote him a question and a letter. Judge Kavanaugh, could you please explain the discrepancy? I didn't get an answer to that letter over the last 11 or 12 years. I think I might get an answer now when he comes before the committee. At the same time, Senator Leahy came up with a memo that was sent to Kavanaugh in the White House as staff secretary on the same subject that was directed to him personally. He was involved in more than just shuffling papers, as Senator Feinstein said. He decided what the president would read and what the staff would propose to the president. Is this relevant to our conversation about his service on the Supreme Court? Exactly relevant, because under oath he stated one thing, and now we have limited but some documentary evidence to the contrary. That's worth a question, isn't it? I think the American people would agree that. So we've come up with a bipartisan standard we've used over and over again with Supreme Court nominees, and unfortunately we're in a position where this administration and this leadership in the Senate has decided to change the rules. It doesn't help us do our job.
Thank you, Dick. And before I call on our guests here, could I ask them to move over a little? These are the missing record empty boxes. We want them filled with records. Isn't my staff good? We now have Kristine Lucius, who's been around here a long time, even though she looks so young. And she is now on the part of the Leadership Conference on Civil and Human Rights. Kristine.
Thank you, Senator Schumer, and thank you, Ranking Member Feinstein, for your leadership. Senator Durbin, your comments take me back to those confirmation hearings and what a stunning moment it was when he responded to your question with a blanket denial of any involvement. And I think that's a great reminder for everyone wondering whether we should judge Brett Kavanaugh's responsiveness by the number of pages or whether we should judge it by the completeness of the record. Because your direct question definitely needs answering. If someone couldn't be honest under oath, should they be elevated and given a promotion? I think that all Americans could understand why that's important. So my name is Kristine Lucius. I work at the Leadership Conference on Civil and Human Rights, which is a coalition of more than 200 national organizations working toward an America as good as its ideals. Before this job, I worked for 14 years here in the Senate Judiciary Committee. So I worked on 6 different Supreme Court nominations. On Friday evening, when Chairman Grassley broke with committee practice and issued a partisan request for a very narrow set of documents, his request, I'm sad to say, I believe is designed to hide 3 years of Brett Kavanaugh's work as a senior political appointee. Kavanaugh himself has said that his work as White House staff secretary was the most useful to him as a judge. Perhaps it is because these 3 years were so informative that the people who picked him, who selected him for this confirmation or for this nomination, want it hidden. All 100 senators and the American people deserve to know Brett Kavanaugh's full record before a hearing is scheduled. This is very important. There should be no rush to judgment with a lifetime appointment of this import. And to add insult to injury, what Senator Schumer referenced is they're not even going through the same process with the National Archives. Instead, we have a team led by a Republican attorney, William Burke, who represents many Trump administration or former Trump administration officials, and I believe also represents former Judge Kaczynski. This lawyer is the President Bush's representative who is reviewing the documents. This person does not owe a duty to the American public like the National Archives would, and so we have real concerns about what documents will be withheld. And this end run around the National Archives and the narrow partisan request leaves us to ask, what is this chairman trying to hide? And what is he trying to do to the role that the 99 other senators need to play with regard to this Supreme Court vetting? It should not be a partisan decision on transparency. All 100 senators have a duty to the American people they represent to independently vet this nomination. Just 2 weeks ago, we saw an appellate nominee, Ryan Bounds, who was withdrawn because of things in his written record. So we had a bipartisan concern that what was in this nominee's record was disqualifying to be a judge. Why wouldn't the same thing apply to a Supreme Court justice? I think it's time that every senator and the American people they represent understand their role and convince the chairman of the Senate Judiciary Committee that they need to see the full record. I think Senator Feinstein's request today that they receive the missing 3 years that were not requested by the chairman, I think that really needs to be heard, not just in the press that follows Supreme Court process issues, but outside the Beltway as well. People need to know what they're hiding and why they're trying to hide it. But I bet that the people who selected this nominee are fully aware what's in that record. It seems to me the senators should have the same access to that record that the people who selected this nominee had. Thank you so much.
Next, we have Daniel Goldberg of the Alliance for Justice. We have a vote.
Thank you very much, Senator Schumer. Thank you very much, Senator Feinstein, and really the entire Democrats on the Senate Judiciary Committee. I'm Daniel Goldberg, Legal Director for the Alliance for Justice, a nationwide alliance representing 130 groups committed to justice and civil rights. For 40 years, AFJ has fought for fair-minded judges, and we fought judges like Robert Bork and Ryan Bounds, who would take this country backwards. A critical aspect of this mission is ensuring that the American people can fully evaluate whether a nominee will uphold critical rights and legal protections. Today, we are deeply, deeply concerned that the public is being prevented from seeing Brett Kavanaugh's entire record. Senator Grassley made a unilateral decision not to request materials from Kavanaugh's tenure as staff secretary to President Bush. But Kavanaugh himself says that job was critical. He said his job was, and I quote, to give recommendations and advice to the president. Kavanaugh tells us, again, a direct quote, whether the subject was terrorism insurance or Medicare prescription drug coverage, he spent a good deal of time on Capitol Hill, sometimes in the middle of the night, working on legislation. So Kavanaugh was a critical official in the Bush administration. The public has a right to know. Did he work towards putting discrimination against LGBTQ Americans in the Constitution? Did he work on the secret Cheney Energy Task Force? Did he work on abortion ban legislation? Did he work on opposing hate crime legislation? I'd like to make one additional critical point. Some are saying this request for Kavanaugh's records is the most extensive ever. Don't believe it. Compare the letters to what was sent for Elena Kagan's documents and what was produced for Elena Kagan's confirmation. In the bipartisan request to Kagan, all documents Kagan wrote, edited, or prepared, or documents prepared under her supervision were asked for. Not this time. That request does not appear in the letter to Brett Kavanaugh. Kagan was asked for documents she created that were in other people's files. And she was asked for documents that reference her. Not this time. Those requests were not made to Brett Kavanaugh. And as has been discussed by Senator Schumer and Kristine, during the Kagan nomination, nonpartisan National Archives staff took the lead in providing documents. This time, President Bush's former lawyers are trying to take the lead. Does anyone doubt the documents are being thoroughly pre-screened? In March, Judiciary Committee Chairman Chuck Grassley said, "I've learned over the years that transparency doesn't come easy. It requires constant oversight and pressure from the public, the press, and Congress." We agree with Chuck Grassley. This is a lifetime appointment that will alter our country forever, impacting our democracy, the rule of law, our rights, and legal protections for every single American. It's time to release all the records. Thank you again.
Last but not least, Elliot Mincberg of the People for American Way.
Thank you very much, Senator, and let me generally thank Senator Schumer and all the senators for holding this press conference, for inviting my colleagues and I to participate. I am a senior counsel and senior fellow at People for the American Way, and I've been involved for People for and others in Supreme Court judicial nominations, literally, as some of you know, for more than 30 years. And in all of that 30 years, going all the way back to Robert Bork, I have never seen a more partisan and restrictive process for the production of documents by an administration on a Supreme Court nominee in all of that period of time. I won't repeat all the specifics that Senator Schumer and others have gone into, but I do want to underline the importance of getting the documents relating to Kavanaugh's service as staff secretary by borrowing an experience I've had working with Senator Schumer on the Senate side on oversight of the Bush administration in its last several years. One of the issues that we did a lot of review on were signing statements. And in fact, the record on that relates directly to Judge Kavanaugh's service as a judge. In one of his dissents from a decision by the D.C. Circuit upholding the Affordable Care Act, Kavanaugh wrote in dissent, "You know, I think that if a president doesn't want to enforce the ACA in the future and deems it unconstitutional, he can do that, even if courts have said to the contrary." And that sounded to me strikingly similar. It's strikingly similar to the view on signing statements that the Bush administration pushed very heavily when it was in office, as both of our committees on judiciary found as we looked into the issue. It's directly relevant to his views as a judge, what his views were on signing statements back when he was the one who was responsible for getting the final form of those statements to the president for him to take a look at, review, and sign. So there is absolutely no question of, as all of my colleagues have repeated, the critical nature, both to the Senate and the American people, of seeing all of these documents. Some pieces of paper, sure, will take about 5 seconds to take a look at and turn aside. But there are substantive documents from the period of time that he was staff secretary as well as White House counsel that are critical for the Senate and the American people if we are to confirm Judge Kavanaugh for a lifetime seat on the Supreme Court. Thank you.
I want to thank all of my colleagues for their good work. One other point I'd like to add. So yesterday I called up the Archivist of the United States, David Ferriero, and asked him, once the letter arrived, to do the right thing, to let us and the American people see the documents. He has some jurisdiction. The Bush Library and this lawyer and others may be standing in his way with claims of privilege or whatever, but the archivist is he's supposed to work for the public. The archives belong to the American people, and I asked him, thank you, Jack of all trades, Elliot, and I asked him to make them public, and he said, you know, regardless of what what Chuck Grassley believes, and regardless of what, frankly, President Bush, who's a fine man but a strong partisan of Judge Kavanaugh, feels, and he said he would give it a careful look and get back to me at the end of the week. Okay? Questions? Yes.
Leader, what recourse do you have if he says no? What will the Democrats?
Well, the recourse is that the American people let their senators know that they want to see these documents. And our next recourse will be to ask Justice Kavanaugh a lot of questions, but we all know these judicial nominees study carefully answers that often dance around the questions. The documents are really a very good way to do this. Yes.
Chairman Grassley has said repeatedly that this would be just a huge cache of documents and at great expense to the taxpayer. Is there any way to sort of narrow the topics maybe to the ones that you're highlighting?
Chairman Grassley didn't seem to feel that way when 170,000 pages of Elena Kagan's documents were sent to the Republicans. So this double standard reeks. And again, people are asking, what are they hiding? We are not intending to be dilatory. They could sign a letter with us right away, and we will work with them on a process to go through the documents very, very quickly. The intent here is sunlight, not delay.
And have the conversations with the chairman just broken down at this point?
Yes, with Senator Feinstein they have, and I talked to him on the floor. And, you know, I think I'd like to believe he knows it's the right thing to do, but is being pressured not to do it and is uncomfortable with it. That's what I'd like to believe. Sonia.
What does this mean for Democrats' plans to do their courtesy meetings with the judge since Democrats have been holding off?
Well, we're hoping we can get the documents because you can do a lot better meeting once you've had some review of the documents, but we're going to see what happens by the end of the week. Yes.
What did Grassley say to you when you talked to him on the floor?
He said it's apples and oranges. That he said, well, the Senate counsel, being secretary is different than being in, you know, in the counsel's office. But that gainsays the fact that Republicans asked for all of Kagan's documents and went back to the Sotomayor days. So it just his what he said did not have any basis in history. Okay? Thank you, everybody. I got to go vote. Thanks, Elliot.
Thank you, Senator.
Thank you very much, Senator.
Thank you. Okay. Thank you. And the empty boxes are here with you.